Colorado Trump Ballot. Disqualification case taken up by Supreme Court. Thank you for spending your valuable time here with us at the Badger Call USA. Please like, share, and subscribe. It really helps out this channel and for higher quality content. On January 5, 2024, former President Donald Trump, a Republican running for president, comes to Sioux Center, Iowa for a rally. A request for an expedited review of the Colorado Supreme Court's ruling to remove former President Donald Trump from the 2024 presidential ballot was granted by the U.S. Supreme Court. The procedural order says the petition for a writ of certiorari is granted. The date of the oral arguments is February 8th. The deadlines for the petitioners and amicus briefs are January 18th. The respondents and amicus filings are January 31st, and any reply briefs must be sent by February 5th. On December 19th, the Colorado Supreme Court issued an order disqualifying President Trump from the race, which left little likelihood of his name actually being removed off the ballot. The Colorado GOP asked the U.S. Supreme Court 3 different questions on December 27th, pertaining to the interpretation of Section 3 of the 14th Amendment and political parties' First Amendment rights to nominate their preferred candidate. President Trump submitted an additional petition on January 3rd, posing a more straightforward query: was the Colorado Supreme Court's decision incorrect? The Colorado GOP's petition has been taken up by the U.S. Supreme Court, which has not yet decided whether to accept or reject it. According to Trump campaign spokesman Stephen Chung, the Supreme Court review was welcomed by the campaign. "We are in favor of a fair hearing at the Supreme Court to contest the decision to strike President Trump's name from the Colorado 2024 ballot, which was made in bad faith, election interference, voter suppression, Democratic support, Biden leadership, and violations of the 14th Amendment," he declared. He went on to say that a number of these challenges, like the one in Colorado, have the effect of disenfranchising voters and have been supported and represented by sizable, left-leaning activist organizations from outside the state. He declared, "We are confident that the impartial Supreme Court will unanimously uphold President Trump's civil rights and everyone else's right to vote in a decision that will permanently put an end to all of the remaining ballot challenge hoaxes." The campaign had released a statement just prior to the Supreme Court's order, highlighting the precedent of comparable cases being dismissed in state and federal courts during the previous week. The first state to declare President Trump ineligible and to hold hearings on the merits of any Section 3 challenge at all was Colorado. The legal theory based on the premise that the events of January 6, 2021 constituted an insurrection and that President Trump actively engaged in or instigated it holds that President Trump is disqualified under Section 3 of the 14th Amendment. It also presumes that different state courts have the power to decide whether a presidential candidate is eligible under Section 3. According to President Trump's lawyers, there have been at least 60 of similar challenges around the nation in recent months. Many courts have cited lack of jurisdiction as one of the many reasons why the majority of these claims have been rejected. Officials and some judges, including dissenting justices on the Colorado Supreme Court, have contended that there could be chaos with up to 50 different rulings if state courts were intended to have the authority to decide whether or not a presidential candidate participated in insurrection and whether that affected his eligibility. Experts and concerned citizens made similar arguments in a number of amicus papers that were filed with the Colorado GOP and Trump petitions. Legislators in other states have already called for President Trump to be disqualified from running for office on their own ballots in response to the Colorado ruling, while other states have called for President Joe Biden to be removed from state primaries. Shenna Bellows, the Secretary of State of Maine, also disqualified President Trump as a candidate shortly after the Colorado Supreme Court verdict, stating that there was little likelihood of her decision actually taking him off the ticket. State court is currently considering an appeal of that ruling, which makes it the third court to find that President Trump participated in an insurrection without any charges having been brought against him or any of the January 6 defendants. A number of further challenges have been filed or rejected in Illinois, Massachusetts, Wyoming, California, and Virginia only this past week. Numerous legal questions have been brought up by the litigation and the diverse range of rulings. Does each state have the right to define insurrection differently under the Constitution? Does Congress have the exclusive power to exclude candidates from office under Section 3? Is it possible for states to forbid candidates from participating in primary elections due to disqualification from office? Or is it possible for Congress to vote a candidate out or exempt them until the day of inauguration? As a result, a number of authors of amicus briefs have asked the U.S. Supreme Court to rule on issues beyond the appellant's requests, such as holding a comprehensive hearing on the case's merits. In an amicus brief on the Colorado GOP petition, 45 Colorado voters urged the Supreme Court to go beyond simply overturning the Colorado Supreme Court decision. They wrote that such a decision would solve nothing and actually makes matters worse. Harms that will spread outside of Colorado's borders have been unleashed by the Colorado court. Thank you for watching. Please like, share, and subscribe for more content like this.